Hello and welcome to the New Indian Express. The Chattisgarh High Court has declared that the virginity test is against the basic human rights of a woman. Now, the virginity test, or infamously known as the two finger test, is a process to determine whether a woman is a virgin or not. Now, international organizations, prominently the UN, has called for a ban of this process as it is a painful, traumatic, and humiliating experience for a woman. So, today to talk to us about this issue, we have Senior Advocate Vibha Datta Makhija, who will explain to us various aspects of this issue. Hello, ma'am. Welcome to the New Indian Express.
Good evening. How are you?
Okay, ma'am. Now, getting into the background of this whole case, why were virginity tests being conducted? What do these tests actually prove in the court of law?
So, in this case, the virginity test was an application was made for the purpose of seeking the virginity test of the wife, because wife had made she had made a submission that as far as their matrimonial relationship is concerned, the husband was important. So that was a point which the husband side wanted to seek a virginity test for the woman to establish that the man was important. So that was this is something which is completely bizarre, because how can a man's importancy be established by a virginity test of a woman?
Now, ma'am, you said that this was very bizarre, especially in a divorce case. So, do you feel that such tests are mainly being demanded by the counsel of the spouse in these divorce cases?
So you see, in rape and sexual offenses cases, now the law has progressed quite a lot. The Supreme Court has passed several judgments whereby the two-finger test, which was usually used to check a point whether the woman was habituated to sexual intercourse or not, to then indirectly determine whether there would have been consent or not. So it was a long chain to determine whether whether the sexual intercourse was consensual or forced. So Supreme Court has disapproved, and numerous high courts have also disapproved of the two-finger test. And from time to time, Supreme Court had made the declaration that two-finger test is completely irrelevant for the purpose of determining consent. But it's an old practice. It has been going on. Then, sometime around 2013 or so, the Supreme Court, a bench of Justice Chauhan and Justice Khalifullah, if I remember correctly, had uh, taken a strong view on this and said, again, ruled that it is completely illegal to do something like that. However, it seems that it has not been followed a lot, and doctors continue to do it. Investigating agencies still call for it. And I think recently there has been a judgment of retired Chief Justice Chandrachud, where he has issued directions to all the family health and welfare departments to come up with guidelines to sensitize the first responders, to sensitize health workers, mental health workers with these issues, and to have programs to educate them that this is a completely irrelevant test. Having said that, it this whole thing having progressed to some extent in the investigating area, family law area, uh, again, uh, you know, I feel that lawyers usually advise their clients to take steps, take chances, and take certain steps. So I think the onus really lies on the judiciary to be very, very sensitive and very, very cognizant of the relevancy of of an application of this nature. So determining virginity of a woman, sexual status of a woman, sexual relationships of a woman is a great invasion of her privacy. In fact, it's a violation of her fundamental right under Article 21. And thus, the courts will have to be more vigilant about the type of orders that they pass. So, the bottom line being this, lawyers will ask for, applications like this. It's really on the courts to make sure that this kind of practice is not encouraged.
So, ma'am, now you were talking about the fundamental rights. What are the fundamental rights that are being violated of a woman when such a virginity test is being demanded? Now, we know that from a human rights perspective, this is a horrific trial or a horrific process that a woman has to go through. But legally, what are the rights, fundamental rights that are being violated?
So, basic amongst this, of course, is violation of Article 21, the right to life and dignity. So, life would include the right to live your life with dignity. And any practice which violates any dignity of any woman or even any other person, even for example, manual scavenging, it is a violation of Article 21. So it's not only in the sphere of, women-related laws. It applies. Article 21 is a very, it, it has a very wide spectrum, and a large number of unenumerated rights fall into that spectrum of Article 21. And the right to privacy, as has been now declared by the Constitution Bench judgment, which everybody knows is popular now. Right to privacy is one of the key rights which is affected. Secondly, sexual autonomy of a woman gets affected, which again is subsumed in Article 21, because the right to life includes the right to live with dignity. So the sexual autonomy of a woman is also, uh, you know, uh, questioned over here. Then the integrity and the dignity of the woman as well. So it's a bundle of rights which are subsumed in Article 21. So essentially, it is a violation, something like this would amount to a violation of a guarantee given under the Constitution.
Okay, ma'am. Now, one of the most landmark cases with respect to this process was, with respect to this virginity test, was Sefi versus CBI. Now, in this case, the investigative agency, that is the CBI, said that illegalizing such a test would result in a direct conflict, it would come into a direct conflict with Section 53 and Section 54 of the CRPC. Do you feel that there is such a conflict that between the illegalizing of this test and the CRPC?
No, no, not at all. You see, the thing is this, that especially after Nirbhaya rape, actually, the two-finger test goes back to the Mathura rape case, where if you remember in early 1980s, there was a young girl, about 16, 17 years old, who had gone to the police station and then she was raped in the police station. So the accused were acquitted both by the trial court, High Court, and the Supreme Court, and there was a great deal of furor after that, because one of the things that were observed in these judgments, in fact, if one were to read the judgments, maybe they are a reflection of the time then, but a highly insensitive judgment. And there is a large deal of time and pages that has been spent on the character of the girl. So one of the findings in that judgment was that it appears because of the two-finger test, she seems to be accustomed to sexual conduct. On that basis, the accused were acquitted, and it was said that it was consensual. So after that, some reforms took place, and there were certain amendments that came through. And Section 114A was added to the Indian Evidence Act, which said that if the victim said that she was abused, then then it would be presumed to be so unless rebutted. So, and then, of course, the custodial rape provisions also were added to 376 in form of 376D, etc. So, and another reform that came at that point of time was with regard to privacy, which was the non-disclosure of the name of the victim, because naming and shaming is very common. So, Section 228A came in. Unfortunate to say that many courts still slip up on this. Still, courts are not very sensitive, especially at the trial court level. So, these reforms came. But it was actually after Nirbhaya that further reforms came. And in fact, Section 53A was added after that, where it was in the Evidence Act, where it provides that the character of the victim of a sexual offense is not a relevant fact. Because basically, when we talk of evidence law, in evidence under Section 5 of the Evidence Act, there is an issue which is a fact in issue, you know. So any fact in issue has to be proved. So courts have now come, and the legislative reform has also come to say that the character of a sexual offense victim is not a fact in issue, or there is no relevancy of her character with regard to the offense, because at the point of time when the offense takes place, there can be no consent, and the offense can take place without, despite her having being habituated to certain behaviors.
Okay, ma'am. Thank you. Thank you so much for talking to us about this topic. Let's hope that the Supreme Court and the other courts take more progressive steps like this and remove outdated evils, as I would say, about like this out of our system. Thank you, ma'am.